Well, hello everybody. I am really hoping that you you can all see me. Thank you very much. I think we have lots of people joining, and you'll be delighted to know that while I hope you can see me, I can't see you. So if you're sitting at home in your funsy, you've got Netflix going on the iPad at the same time, got a big mug of hot chocolate or something, hopefully I can entertain you a little bit for the next hour. Although entertainment might not be quite the right word for claims arising from death, which is what I'm delighted to be talking to you about this afternoon. So I've got a very large presentation and I will go through some of it, most of it, and I will, but the slides will all be available to you online, or we can email you copies of them afterwards. So there will be some slides that I'll literally say you might want to read this later rather than talking about them, and I'll endeavour to pick out some of the more interesting bits and pieces of fatal accident act claims as we go along. Because one of the things that I think is interesting about fatal accident claims is that people seem to find them a relatively scary or unfamiliar area of law. And it's really because it's statute based, I think, and isn't something that we come across every single day. But because it's statute based, it is broadly easy to understand what is happening once you know where to look. So the first thing to remember is there is no remedy for a claim for death or an estate at common law. Once you're dead, it's all over, bar the shouting or the statute. So it is entirely contained within two acts, both old, the Law Provision Miscellaneous Provisions Act 1934 and the Fatal Accident Act 1976. And they have remained remarkably unchanged, actually, over time. There's little bits of tinkering that we'll come on to, but it's really contained in those two acts. And then there has been some movement, but not a lot of movement, brought in by the Human Rights Act, which I shall touch upon. So you start off with the Law Reform Miscellaneous Provision Act, and that is the claim brought on for the benefit of the estate. So very simply, one wants to consider that essentially as what would have been a personal injury claim had the claimant not died. So it covers damages from any period from injury up to death. It is the claim of the deceased, and it is also their claim that arises from their death. So funeral expenses are recoverable under this head of loss as well. So very simply, think about the claimant as if they were a claimant although they're deceased. So they have pain, suffering, loss of immunity as a general damage if the death is not instant. And that's almost always the case, even if somebody is known to be, if somebody's unconscious, even if they're unconscious and there's a relatively short period before death, there will generally be a claim. The fact of most of the fatal accident claims you really couldn't make up if you tried, and whenever anybody tries to come up with examples, you'll find that the real cases are even more extraordinary. But anyway, PSLA if death's not instant, traditional specials, but there's no lost years claim after death. So if you have a claimant who is alive and they have a reduced life expectation as a consequence of harm, they can claim for that lost years while they are still alive, but not once they are dead. And that's something that you often see, for example, in occupational disease cases, and that might affect or influence an advisor as to when a claim should be brought. So that's the broad outline of the Miscellaneous Provisions Act, and then the other statute is the Fatal Accident Act 1976, which is the claim that exists after death can be brought by the executor or administrator of the estate. If there's no executor or administrator, it can be brought by anybody who would have had the benefit of executor or administrator if they could have brought it. But the key thing to remember here is that no more than one action can be brought. Now, in practical terms, that can often lead to considerable difficulty if, for example, you have a family unit with more than one family. So if you've got a wife, an ex-wife, and a cohabitee, two families, lots of dependents, they all have to bring the action in one claim. And the thinking behind that is logical. When you think about dependency, has to be dependency on that deceased person's income. So if you're carving up what they earned or what time they had, or any element of dependency you would have had on that deceased person, just as warring family units would have had to fight over who got weekends and who got income and who got the second house and so on and so forth in the family courts. Sadly, so too after death, they have to carve up and make an agreement between themselves. It can be pragmatically very difficult for the advisors, both claimant and defendant. You often find a defendant has more than one claimant with representatives for, wife, ex-wife, etc., etc. As a claimant, the concern is ensuring that you have got all the family members and all the potential dependents within the claim. I've had a claim when there were 16 dependents in the end, because it was a very large family, and the deceased woman, in fact, she sent money to many aunts, uncles, cousins, many people were dependent on her, and gathering them all together into one action took a fair bit of corralling, as you can imagine. The point to remember is, however, it's not a claim that just grows with the number of claimants. And one of the things I was representing the claimant in that family, that the deceased, predominantly her birth son had the largest claim, was reminding the relatives that the more of them came into the pot and sought a bit of money, the less money would end up going to the son, because she couldn't earn more than she earned, and the dependency couldn't be larger than the dependency was overall. You just have a cake that you cut into ever smaller slices, but no more than one action can be brought. So next slide is for whom can the action be brought? So the deceased must have been entitled to bring an action. So there must have been a tortious act resulting in a personal injury. Sounds pretty simple, and in most cases it is. Very occasionally it becomes an issue. For example, suicide caused by a tort, that's been decided not to extinguish a claim. But there's no claim if there isn't actually a tortious action, if it's not a death caused by injury or disease. And the action, as I say, is for the dependents, however they may be carved up. And one thing to remember while you're trying to corral all the claimants into one pot is also to beware an early or previous conclusion of the claim. Once a claim has been concluded, with all of the claimants involved, you'll be too late to bring your claim under a second claim form. So that's something for claimants to beware. On the other hand, for defendants, beware trying to resolve the claim too soon. The quite recent case of Cor and Brocklebank, you may or may not have heard about, but in that there was a son who was killed, a young man killed in a car accident, and his father brought a claim on his behalf. And at a pre-action stage, there was correspondence between the parties, funeral expenses, and the Miscellaneous Provisions Act claim. They sought bereavement. Sadly, he was over 18. I'll come on to that. No bereavement. But the father also made a claim for dependency. There was a Part 36 offer letter that was accepted, and it was expressed to be for the whole of the claim and for the whole of the dependency, bereavement and funeral costs. Immediately after settling it, an email was sent saying, well, actually, the mum and the other siblings have also got a dependency claim. Now, it ended up being, because there hadn't actually been a claim issued, and therefore a claim hadn't been generated under the Fatal Accident Act, it couldn't have been one claim brought. It couldn't have encompassed all of the dependents. And so while the father had compromised his dependency claim, the other siblings and the wife had their dependency claim to bring. So beware if you're seeking to resolve a claim at a pre-action stage to ensure that everything is encompassed within it, and/or you may find that it's not possible to do that without an actual issue of a claim and a claim form to ensure the dependency is wrapped up. Now, of course, again, that still won't increase the pot of damages that there are. But if, for example, as in that case, it was a young man and they were saying, well, he'd have given some money, or he'd have given time, or he'd have given this, he'd have given that, the defendant in that case ended up having to pay an extra sum to resolve that further dependency, even though they thought they were home dry with their Part 36 offer. The father couldn't bring another claim because he had compromised under contract. But there we are, point of note. Quite a lot of points of notes. The first is when you're looking at who can bring a claim. There is a statutory list. This is a creature of statute, and there is no discretion under that statutory list. For Fatal Accident Act claims and dependency, there is a 2-year rule for cohabitation. And you have to have been living together as a family unit to have a dependency. And if you haven't lived together in that 2-year unit or been married, then there's no claim. You can be married one day and you're away. Cohabitation 2 years, and there are all sorts of cases. I mean, it's extraordinary. Quite often you've got young men who are in the military and they're going off to war. They meet someone, have a quick fling on a Friday night, married on a Saturday, go off to war on a Monday, curtains on Tuesday, and the widow has a claim of somebody they've barely known, and you've got another couple that have lived together for years, been a settled couple, but haven't actually cohabited for various reasons of work and etc. and they won't qualify as a cohabitation despite having had a settled relationship for a long time. It is a creature of statute, and it cuts its cloth in a particular way. On the other hand, the list is pretty kindly to blood relatives. You can see here's a massive list of immediate family units of who can, sorry, I've gone on too fast, who can claim grandparents, grandchildren, aunts, uncles, Uncle Tom Cobley and all. Hence you get the 16 claimants as I had in my case. But weirdly, a surviving child of an unmarried partner is not dependent even if living as a family unit. And that is a set of circumstances that I've had exactly. I had a delightful but rather strange family unit. The deceased man, he was a milkman actually, and he had met a woman and never married her. She had a 3-month-old when they met. They'd lived together for years. Bizarrely, they didn't marry, but she changed her name by deed poll. So as a family unit, they all had the same last name. And the child didn't even realise that the milkman wasn't his birth dad until when he was age 7. The child, obviously not the milkman, when he was age 7, the milkman was killed. And technically, there was no dependency claim for the child dependent, not a creature of statute. As it happened, I was with the claimant on that occasion and ran an argument saying it was essentially an infringement of his human right, and we managed to resolve the claim on a settlement basis with very little discount to reflect the dependency of the child. But technically there's no claim. So that was reinforced in the Court of Appeal case of Swift and the Secretary of State for Justice, which essentially said there was a generous or wide margin of discretion for Parliament when they were deciding who would be able to recover for dependency, and it was a legitimate right to have a 2-year cohabitation requirement, and if that is what statute had required, there was very little doubt and no discretion for the courts. Now, the wide ambit for the Fatal Accident Act dependency is in distinct contrast to the rather narrow list of dependents or bereavement awards. There is a very specific award which is recognised as being pretty tokenistic, and in a day when we have just seen there's a lump sum of 60,000 being awarded to those that have died in the public realm of their action for in the coronavirus crisis. The sum put on healthcare workers of 60,000 as a lump sum payment it is a clear indicator of the limit of the sum of award for bereavement damages when it is a considerably smaller sum. Very narrow list of people able to claim for bereavement. You've got to be married and you've got to be or a child under 18. Now, again, as I say, in these cases, you can't make up the facts. You have to be married. You can still claim if you're in the process of divorce, but you can't claim if you're divorced. In Hayes and the South East Coast Ambulance Service, poor old Mr. Hayes, or rather poor old Mrs. Hayes, Mr. and Mrs. Hayes had been married, they got divorced, and then got back together again, fallen in love again, and were on the point of marrying, but at that point were divorced. Mr. Hayes dies, Mrs. Hayes, no bereavement claim. Even more oddly, we are deemed to suffer bereavement if our children die when they're under 18, but not when they're over 18. And indeed, there's a case of a child injured under 18, died over 18, no bereavement claim because it goes in the date of death. And again, only if they are a legitimate child. So in that circumstance, mum can claim, but not dad. Right, that's that narrow list. And then we move on. It's a creature of statute. It's set and raised by statute. And it's one of the areas where Scotland and Wales, well, Scotland often, but Wales not often, do their own thing. It's just going up, so a timely and topical talk, because not much changes in this world, but in a few days' time, anybody dying after the 1st of May will have an enhanced sum of 15,120. If you died between April the 1st, 2013 and 1st of May, you will only get 12,980. It's one award and it's shared. There's more than one person capable of covering it. So in the case of an under 18, 2 parents can share it. But of course, as I said before, not if you're over 18, children don't get it for their parents. So there we are. In different jurisdictions, there's different awards. Northern Ireland, a bit more generous, no, less generous after the 1st of May, 100 quid in it. Damages in Scotland, however, are done in an entirely different way. They're assessed by virtue of an actual relationship, PSLA type award. And I think there's been a 6-figure sum for if you have a lot of love and affection and a lot of bereavement, I guess, you can get a lot of money in Scotland. It's an entirely different beast. It's been raised by April and many others as an indicator of a way to go, but funnily enough, it has not gained much traction with the MOJ. However, what has gained a little traction is the other recent case. So we've got a Swift, now we've got a Smith. Smith and Lancashire Teaching Hospital and the MOJ. This was Jackie Smith brought a claim for a declaration of incompatibility as a cohabitee of many years standing. Why on earth, she said, should I be able to recover for dependency, but not the piddly sum for bereavement? To which there could be no good answer. So a declaration of incompatibility was duly made, and having dragged its heels a little bit, there is then the Fatal Accident Act remedial order laid before Parliament, which should be coming into force soon. Although with Brexit and with virtual Parliament, who knows what's going to happen, but it's due to come into force in June or July this year. And effectively, that will mean bereavement will now sit more comfortably with the Fatal Accident Act and a cohabitee with 2-year plus cohabitation. So the same rule under the Fatal Accident Act will be able to recover their bereavement sum as well as their dependency claim. So the government, as I say, acted in accordance with the Court of Appeal ruling. Now, there's lots of problems with Fatal Accident Act claims, and so the Joint Select Committee, who were asked to look at bereavement, had a bit of a punt and had a look at wider reforms, change of language, increasing amount of damages, considering a more natural approach to looking at family, communities, and a slightly more mishmash world in which we live in these social times, all of which everyone said very interesting, but gave about as much traction as they did to a rather excellent paper that was produced many years ago by a law reform group looking at ways in which fatal accidents could be better dealt with, which was a fine document that sat and gathered dust for many years. Anyway, there we are. There'll be a rise and cohabitees can now get it. So, is there a dependency? The first thing that you need to look at when you're looking at whether there's a dependency claim to be made, so this is the fatal accident claim, you've worked out who your person is, you've got your bereavement out of the way, but is there a dependency? It's got to be a pecuniary advantage at the time of the deceased's death. Now that might be something that is anticipated in the future, but that eligible dependent has to have that pecuniary advantage at the time of death. And it is sufficient, as I say, to have a reasonable expectation of that pecuniary benefit. So due to the kind of small amounts of money that can arise, you'll see later on there can be some fairly imaginative ways in which there's a reasonable expectation of pecuniary benefit, including I've paid for my daughter's education so that she can become a doctor and look after me when I am old, sad and sick, and I will therefore have an expectation of dependency going forward as a viable argument. But the level of proof that is required has to be a substantial possibility, not more likely than not, a substantial possibility. Now, of course, the difficulty for defendant is that it's often a question of saying, I don't believe you really, and you didn't really say that, and that's not how your life was, when you've got a claimant who is essentially giving their evidence of how their best life would have unfolded and what it would have looked like going forward. Now, of course, you can make a call for evidence and one can examine quite closely the sort of reality of the situation, but it's a peculiarly anecdotal area of law. And very often it is a matter, because again, if death isn't expected, you have life up until death, and then the claim is almost always in a process of change, either in your claim for services, everything's changed because of the death, therefore we are now doing X, and also a dependency, You may say, well, we have a clear dependency on income, but what would have happened going into the future? Just as we're always in a state of educated make-believe when we look at future losses by educated guesswork of what would have happened but for the accident and what will happen now. You've got that sort of extra layer of the person being deceased. So really what is happening as a consequence is yet another variable to throw into the mix. So other factors to bear in mind. You can have contributory negligence, no problem there. Section 5 deals with that. You can look at remarriage. So you specifically mustn't take, oopsie, sorry, I've gone forward again. Let me go back. Oh, I'm getting too overexcited. Oh no, that's, oh, I'm getting the wrong way, hang on. Right, there we are. You specifically can't take account of the fact or prospect of a widow remarrying. It's perhaps indicative of the timing of this legislation, anticipated that it would be a male deceased with a female unearned dependent. Now, you know, question, it could fall foul of the Human Rights Act, looking at not taking account of the widow marrying, but you can take account of the widower remarrying. But potentially, I think this can all be sort of swept up into the great disregard that is Section 4 of the Fatal Accident Act, which is generally the only section that everybody's heard of, which is a disregard of any benefit that accrues as a consequence of death. And that is the significant factor when you are looking at going forward. If somebody has had a benefit, often an insurance payment or a significant payment out, or a death in benefit payment, then that is entirely disregarded when you come to look at the loss and the dependency. It is frozen in time at the point of death, and the dependency is based on that going forward. Now, a breakdown of a relationship is something that can be considered, but you have to take into account, again, as far as you can, the reality of the situation. So if there's a lack of enforceable right to financial support, that's got to be taken into account. On the other hand, if you have a settled couple, a married couple, even if there was a breakdown, the person who was being left behind would have had a right to call on the deceased for dependency in the family courts. Then that will also have to be taken into account, whatever anybody else may say. A prospect of marriage breakdown can be considered in an assessment, and I always feel a bit sorry. The Dazil and Donald case, the deceased dependent discovered that her partner was planning to leave her and having an affair when he was killed on a motorbike with the other woman on the back. And that is when she discovered for the first time that all was not hunky-dory in the home. And so not only did she have to go through the trauma of bereavement and the exigencies of litigation, she also had a hefty discount applied because, unbeknown to her, the prospect of her marriage continuing wasn't great. So there we are. We never know what's around the corner. So, Human Rights Act can also be taken into account. Now, there is, not surprisingly, a whole lot that can be said about human rights, and you'll be delighted to know that a future webinar will be looking at Human Rights Act and particularly clinical negligence claims, civil claims. So that'll be a treat to look forward to. All I'm really going to say now is that it is an area to bear in mind, and it is the third great statute that covers these claims. The relevant article is Article 2, which is the right to life, and it's really confined to situations, obviously, where you've got a citizen's convention rights being breached by a public authority. So in the grand public sphere, hospitals, prisons are generally, the areas in which we will be engaged. And there can be a right to bring a claim if you're a victim pursuant to Section 7, and that can be a direct or indirect victim. So that can be the deceased as a direct victim or an indirect victim as a family member who is closely connected and suffers as a consequence. There's a fantastic chapter on Kemp and Kemp in this. I won't go into it now, but you can read there about looking at what those relationships may be, particularly for the indirect victim, somebody who has a close personal relationship and an engagement there. And the key kind of case, the successful claim in Rarbone is a brilliant place to start. It's referred to in almost all other cases. And that was a tragic case with a mentally ill 24-year-old. She was let out of mental hospital. She wasn't actually forcibly detained, but she was let out and she subsequently committed suicide. It was deemed there was an operational duty to protect the deceased from the real and immediate risk of suicide, and that was the breach. That was the breach of Article 2. So there can be a systemic relation. There can be a systemic claim, and there can be the operational duty. The breach of the operational duty, given that there was a real and immediate risk to her life by suicide, meant there was an assumed responsibility for her welfare. These are the facts. Nobody would have let her out. No reasonable psychiatrist would have let her out. Breach, negligence, and therefore there was a Human Rights Act claim. Now, two other things to bear in mind. Firstly, that there is no renunciation of the Article 2 claim by virtue of settling the Miscellaneous Provisions Act claim. So damages have been paid to a young woman, damages have been paid for her funeral, and so on and so forth. And that settlement didn't prevent the parents bringing an Article 2 claim. And the second point is there's only a 1-year limitation for Human Rights Act claim, not 3 years. In the usual fatal accident, it's the same as personal injury. That was expressly dealt with in Rarbone. It was brought 4 months late, and the Supreme Court gave consideration to, they said we would consider the issues that would be like a Section 33 claim, the Extension of Limitation Act under Personal Injury and Fatal Accident Act claims, but it's not the same, but we'll look at some of those issues. There are cases that have come in and there are cases that have fallen out under that 1-year rule, so that's something to bear in mind. And then there's also a look at an encompassing of what those Article 2 damages may look like, and they go from quite low, kind of £2,000 up to sort of €60,000, depending on various factors of domestic and international law. I mean, in this case, they were both £5,000 each, and it was deemed a bad breach. So it's not a bank-breaking sum. It is often tethered to or considered in other cases in line with the bereavement award, but it's something to look at, and it is something in the right case to bear in mind. Now we come on to the exciting bit. Assessing lost services. So what I've tried to do going through is to pick out some of the key areas of difference from personal injury claims and difficulty in making those assessments. And I think lost services is one of the key ones that can cause difficulty and confusion. And that's predominantly because we are all exceptionally au fait with care claims. And we know a care claim, and we can pull out our facts and figures, and we can get an hourly rate, and we can knock it off by 33 or 25%, and blah, blah, blah. And off we go and look at reasonable need. And this, in fatal accident acts, they look the same, but they're not the same. So Section 3 is the starter, and it's in an action for damages other than damages for bereavement. It may be awarded as proportion to the injury resulting from the death of dependents, and apportionment between the dependents in such shares as may be directed. So you're looking at all the range of loss of services in the usual, so to speak, in the usual PI way. So that can be anything that would have had a benefit that isn't earnings, but is a benefit. So DIY, gardening, care, car servicing, IT skills, babysitting, cooking, future babysitting, looking for grandparents, car washing, all the myriad of things that are pragmatic things that would have a pecuniary value if they weren't done for nothing. Those can all form part of a loss of services claim. So most commonly, you have this sort of claim when you've got a deceased who is a father or mother looking after children. That's the big one, because obviously that's the expensive one. And then what you do is you look at the life expectancy of the survivor as well as the life expectancy of the deceased if they haven't already died. So you might need to have a desktop report or a GP letter if there's no access to medical records, but you go by the lower of the life expectancy. Now obviously for children that tends not to be very difficult because the children would expect to grow up before their lost parent was unable to look after them anymore, but it can be important in cases where you've got a care or dependency between a couple and one looking after another. Then you need to see which of them would have been likely to shuffle off their mortal coil first had they not already been killed and given rise to the claim, if you see what I mean. So you look at that and then you go by the lower date. So essentially the court, you can see here, looks at it as a sort of jury award. So they look as if they were a jury awarding damages. And what's reasonable compensation, looking at the overall lump sum for the loss sustained. So, not surprisingly, it's often pretty uncertain. Percentage reductions can't be entirely mathematical. Generally, it's the kind of thing that makes Victoria Wass kind of go a bit crazy. Everybody does some really strong calculations using all her actuarial figures, and then they swinge off a bit of percentage for all those known unknowns in the Donald Rumsfeld way that we all have to cope with on a daily basis. So, what is the test? It is not a replacement, but it is an anticipated cost of meeting the claimant's needs as against what the deceased would have provided. So you have to look at what the person who requires the service delivered to them, what do they need? And so, for example, that makes a big and significant difference when you look at care provided to children. Because in the usual way of a care claim, you would say, well, you would take an hourly rate, and if somebody had given up their job and lost more money as a result of that hourly rate, you would take the hourly rate. Whereas here, you can look at saying, well, actually, we need to replace it by buying in a nanny, which is a much more expensive provision of care. But that is the claim, because you're looking at it for meeting the need that has been found wanting. So with the financial dependency, you've got to show that the deceased would have continued to provide it, and for how long. But of course, it doesn't have to be certain. You have to have a real possibility. So Hayes and Hughes, again, pretty old case, indeed 75, but it's before the Fatal Accident Act. It's even older than that, but it's looking at the best instrument for assessing loss of dependency, being the cost of a nanny carer over the period during which the dependent would have received the benefit. So basically, the length of time the children would have been looked after. And you ignore the support that has in fact been received, because of course you have your section 4 disregard. So the fact that granny's been sort of rushing around making porridge in the morning, and dad's been covering together dinner at night, and you've got by on that amount of care or that amount of provision of resources in the time before settlement, doesn't mean that you're not entitled to claim for the cost of the nanny, if that is the best way to provide the care. And the commercial cost can be enhanced. It's one of the very few times actually when the special features of care and attention actually do translate into pecuniary advantage. And it's recognised that even the best nanny, perhaps not Mary Poppins, but other than all bar Mary Poppins, would have provided a little less care and a little less love and attention than a mum, or indeed a dad, but the care providing parent, and therefore there's an uplift for that. So if you have employed a housekeeper or a nanny, then dependency is likely to be looked at by that actual cost, because that will be referencing the replacement. But if you've been muddling by, it doesn't prevent you from looking at what ought to be put in place, as I've said. You do need to have an eye to the future, and so the fact that as kids grow and will be needing a little less care over time, then that can be taken into account, as can the fact if the mother was caring part-time, or there was a sort of mismatch, but essentially you're replacing what has been lost. So in Knauer and MOJ, this is the case, most of us know it because it's the one which overturned the setting your multiplier by the date of death rather than by the date of calculation of the claim. But in this case, in fact, it's also interesting for looking at it from the point of view of care provision, because here you have a couple. Mrs. Knauer died at 46 of mesothelioma, poor lady, and basically she cared for her husband, who had quite considerable wants and needs. 5 years from death to settlement, not unusual. 5 years, in that time he'd muddled through. He hadn't had a cook, he hadn't had a cleaner, hadn't had anything, and therefore the defendant said no damages for loss of services past or future, because he didn't have loss. He hadn't done anything, he hadn't incurred any costs, and he could get by as he was. He says, sorry, I just hadn't been able to employ help. Tasks hadn't been done, wife would have done them, and therefore he had a real need that hadn't been met both in the past and the future. And Mr. Justice Bean said, yep, that's pretty much okay. The defendant's argument ignored the basic principles of tort, looking back at Hay and Hughes, and made this nice little quote: the fact that a widower decided to manage himself after the death of his wife would not disentitle him to sue for and recover damages for the pecuniary loss he has sustained. So the court must assess what has been lost in the past as well as what will be lost in the future. And in that instance, it was 16,640 a year. So you can also look at the non-commercial care. So if you've got father, other relatives, grandparents who step in, you generally plead it not at the commercial, not at the gratuitous care, but at the commercial cost. But you can reduce it by 25% to net value because you haven't paid tax or national insurance, and look at a Hashcroft and Burdett reduction. Here we have a little bit of McGregor on damages, telling you in more elegant language what I have already told you now. The final warning: attempt to bring relative services into account by way of deduction are misguided. See collateral benefits. So there we are. Have a look at that. Always a cracking read. So ignore benefits after death. As I say, section 4, disregard. You disregard benefits after death. So you disregard the provision of care by the granny, provision of care by this, that and the other. You look at the cost of replacement as a nanny. Reduce it over time. No double recovery. So for example, instances where children have been sent to boarding school, you can't recover the cost of the school as well as a nanny at home. Can have an additional care for love and support. And loss of chance for future projects. So, oh yeah, so here we have, what do you do here? This is an instance of a case with 3 adult sons, but they claim dependency on their deceased parent. How so, you may say? They no longer need a nanny, but essentially they say they would have had money, it would have been set aside and given to them to help buy a house, to help pay for weddings, on family holidays, or so on and so forth, and they would still be entitled to dependency on that basis. And that's a perfectly legitimate claim to make. Bear in mind that if the widow or the surviving spouse is also making a claim, it doesn't increase the overall pot. So those sums will have to come out of the overall dependency. But you may say, if you're doing a Harris fraction and saying, right, you've got 66% to the surviving widow, the payment to the adult children would have come out of the deceased's third, that they would have had to spend as they like, and they would have liked to spend it on their kids. So that's a workaround to increase the overall pot by saying you've got your 2/3 plus that comes out of the remaining third. But I would say you'd still have an argument against the total amount being greater than a 75% Harris fraction, which is what you do when you have dependent children and spouse. 75% of the total income, and it certainly couldn't be more obviously than 100% of income. So how would you challenge it? Discount it on contingency. How likely is it going to be this is all going to come out? Look at the overall pot, as I say. And again, you can have tax-free wedding gifts, £10,000 a year tax-free per wedding, £3,000 a year gifts, and so on and so forth. All kind of financial planning, if there's sufficient income in the family, can be looked at. My time's cantering on. So these are instances where carers have given up their own job, all of which are deemed to be broadly reasonable. And you may want to look at those in your at your leisure. But I'm going to canter on because I want to look at some of the other issues. This is more on services. It'll all be there for you to see. Here's instances when you have dependency on services without children, same as Canara. You can still have an intangible benefit as Zambada here. You've got a claim loss. Next thing is a general damages award, Regan and Williamson, or top awards, which are generally the special qualitative factor of lost maternal care. Now, these are sometimes a way of sort of bunching up and hiding the shame of the fact that there's no bereavement damages for children who are not meant to miss their parents. But this is a reflection of that special extra loss and that special extra factor. In Mehmet and Perry, it was awarded to husband as well as children, even though husband would have had the bereavement awards. Here in HNS, it was awarded with the Court of Appeal saying a maximum of 5,000 for very young children. It can be challenged though. You can challenge it and say clear that bereavement is there already paid for grief and loss. challenge paying it out for a second time, but it's a way to fill out a loophole for children. So what should an action plan be when looking at these claims for both sides? Look for evidence, look for disclosure of spending patterns, or look at ways of spending money. A defendant can perhaps look at social media to try and ensure that there's an active relationship. You need to focus on what is happening and not reasonable need. So that's an important way of determining the cost. But as I said, the sticking point is very often a kind of one-sided recitation of events by the claimant, although it can be very difficult for a claimant to cogently prove something, which is why so many of these cases settle, because it's so often, we generally operate in the grey area. Boy, is there a grey area in your average fatal accident claim. However diligent either party is being to try and fill that gap. You can always make look for a poor relationship, and as a defendant, challenging a poor relationship is a significant way of looking for a relationship and for looking for a limit on a claim. But of course, it has to be at the time of death. If there's been something that's happened afterwards, like a disregard for future weddings, you can't bring that to bear. Calculations. Now, this is really your maths homework. I'm not going to go through this with you. Because A, it's boring to describe, and B, it's far easier to look at. But what I've done for you here is I've set out the dependency. Now, I've already discussed Harris and Empress Motors, and I'm kind of assuming, and I'm kind of hoping, and none of you can tell me otherwise because you just can't, that you've heard of Harris and Empress. If you haven't, have a look at it. But essentially, this is the basis upon which you make your reductions of 66 or 75%, depending on how many claimants there are in the pot. Coward and co-mix holder is what you do if you've got the other partner earning as well. And here are some calculations worked out for you. I've used simple maths because it makes it easier, but the principles are all the same. And then calculating the multiplier is the next thing. We've already talked about Canal and MOJ, which changed the law, declined to follow Cookson and Knowles, multiplier from the date of trial, not death. So it's basically in line with personal injury claims, and you can use the Ogden tables in broadly the usual way. The front of facts and figures has a pretty helpful, paper on how to use it. And then we come on to, as I've already talked about, section 4. Now, section 4 is the important section. The assessment of damages, disregard of benefits. You have to not look at anything that is accrued since death. Now, section 4 is also interesting because what do you do when, this is a more interesting bit to have a quick look at, when you've got what we call wealth creators. So the trio of cases, Wood, Benthel, Simplex, Cape Distribution and O'Loughlin, and Welsh Ambulance Service Trust. Now, these are all cases where you have got, no, I don't want to do that, I want to go back to previous, I'm going to go back previous and go through them one by one. Right, where you have got a situation where at first blush it appears that there is no loss because you have got a business that continues to increase and indeed often improves after death. Wood and Benthel Simplex was a farm. Very good farmer, had a big family, had a big business relationship, and you cannot recover for simply a business relationship. And there's that very old case, which I can't remember, when poor people, they were married, but they were deemed they were ballroom dancers, and the dependency was deemed to be a business relationship because they were professional ballroom dancers, not a family relationship, and therefore the surviving dancer got no money. So bear in mind, it has to be a family relationship. But that provides the way through cases like this. The family business, the farming business, had got better, had got bigger, and had expanded because it was a family business. And there was more than one of them farming. Lots of young lads carried on and worked through. But that wasn't the way in which the dependency was based. Because what it was based on was the wealth-creating dad had overpaid his family for the work they did, but there was a loss of dependency, because the dependency was reduced by the energy he would have brought to the business and the expansion he would have made. Now, the question was, could the dependency given to the widow, the amount of money given to the widow, be reduced by taking into account the fact that the business had grown since the deceased was killed? No, it couldn't, because you can't look under Section 4 and Section 3, the remarrying cover kind of that. You have to look at the loss that has been suffered. And has there been a loss suffered as a result of death? And if there is, what are the appropriate damages for that loss? So how do you look at the loss of the wealth creator? And it's difficult. What can be done? In Cor and Brocklebank, he ran a very successful property portfolio. And the widow got the properties, and she wasn't much interested, so she sold a couple and lived off the income, and had a capital investment and lived off the income of that. And you could say there's not a loss. And in the business, there isn't really a loss. However, there was a loss because what she had lost was the ability of her husband, who was a wealth creator, with his flair to increase the business assets. And so in that instance, they looked at a manager or somebody who would have that flair to increase the business, and the loss being calculated with relation to the sum that would have had to be paid to him. Similarly, in the case of Welsh Ambulance Services, the deceased had entrepreneurial skills which he passed on to his kids. So there was a big business, and indeed at the time that he died, when he was knocked over by the ambulance service, 2 sons were involved in the business, and a 3rd child came on stream after he died. But the family all worked together, and the business flourished and indeed grew. The wife had no part in the business, but is often the case. She was paid £30,000 of services paid by the company. But essentially, again, the whole family worked together, but the benefit, the loss of the deceased, was beyond their individual contribution, so they valued his loss as a wealth creator. And you had to have a consideration of what that cost would be, and the continued success of the business. So those are cases to have a look at and to have a think about, and I think that's a very common situation that that we come across when trying to value the more complicated cases. So the challenges of the future are looking at the business itself. You can't recover for the pure economic loss. You're looking at the role of the deceased, the replacement of the role or the salary. You have to disregard how things have improved after the position. You've got to disregard the improvement after death on Section 4, but you have to think about the appetite of the family, what they've lost, and how much they're prepared to fight as well. Okay, will Section 4 survive? Lord Sumption had a bit of a pop at it, but I think yes, it will. You can read that, quite an interesting case. He thought it was a departure from ordinary principles. But yeah, I think it'll survive. That's my, you can come back and haunt me later, but luckily I'm not a judge, so nothing I say goes much further than your bedrooms, really. Okay, final points. You'll be glad to know we're nearly home and dry. So lost years, that's something to be looked at. I went right at the beginning, but the important point here is that a claim that is brought and concluded before death can't be revived. Lost years can be claimed before death, but not after. So sometimes you have to think about where, I mean, sadly, if you've got a claimant who is going to die, whether you want to put the marker down for the claim before death or afterwards. So you can have, for example, you can have a care claim for the claimant, soon to be deceased claimant. They might have a very high care need in their final years, and they may have a very high lost years if they had significant earnings. And you recover all of their earnings, not a proportion of their earnings, because it's their loss. So that may militate towards bringing in a claim before they die. On the other hand, you can lose out because while there will there'll be no care claim of the deceased once they are a deceased, there'll be no, sort of going forward, obviously the care that they had at the time of death will remain, but there'll be no care claim going forward. There'll be no, there'll be a proportion of earnings because you have a dependency on earnings, which is never 100%, but you will have a future services claim, which may be higher than a claim that is brought before death. So that's something to think about if you're in the invidious situation of advising someone whether to bring a claim before or after death. Periodical payments can be awarded in fatal claims. Section 7, not many people know that. But it can, for example, resolve an argument on dependency for children. If you've got an argument about whether they'll go to boarding school or whether you have a nanny or whether they'll go to university or how long they'll be dependent. You could just say biff boff periodical payment until it no longer matters. Or, for example, in the case of something like Canary, when you've got a care claim for somebody who's quite disabled and survived and has a need that was met by the deceased, you can have a claim that would last for their life. So they are looked after and their dependency on services is dealt with. And there's a couple of examples. I'm sure there are more. Finally, don't forget apportionment. So although Fatal Accident Acts claims are a funny old beast, because you will almost always need approval if children are involved, because CPR 21 requires that to be done. On the other hand, the bulk of the damages will be damages for the dependency of them while they are young. So you don't want to lock the money up until they're 18, which is the normal course of events, because you need that money to be fed through to them to pay for their education. However, the court will want to have oversight, and the Court of Protection may be involved in managing the money thereafter. And the main flexibility is very often given to the surviving parent, who has generally in the course of 4 or 5 years after death and before settlement shown themselves to be admirably equipped with stepping into the breach and setting up sensible and pragmatic ways forward. Personal injury trust, some kind of mechanism of managing money that will enable them to have access to the damages that they need in order to put in place the care their children require as they grow up without their missing parent. In those instances, the bulk of the money will be paid out immediately, or essentially will be left within the body of the award, but there will nonetheless be a small amount set aside by way of apportionment, so that at the age of 18, the children come into some specific money of their own. How much that is really depends, but it is effectively a tokenistic gesture. And there are various bits and pieces in the very excellent Kemp and Kemp chapters. There are 2 very good chapters actually. The chapter on human rights has a cracking bit on fatal accidents, and the Fatal Accident Act case also has some very good examples of apportionment. I've got actually it's quite an old case. I probably ought to find a more recent example, but essentially showing we had damages of 430,000. The vast bulk of them were given to mother to bring up the children, but 20,000, 15,000 were given to children to be set aside into court until they were 18. And I think that sort of figure of between 10 and 20,000 is pretty normal, to be honest, in my humble experience. But it needs to be considered, and that apportionment and that advice and settlement needs to be ratified by the court to be binding. So, oh yeah, that's it actually. Okay, so that was pretty much everything I was going to say about fatal accidents. A bit of a romp through. I hope some of you are not entirely dozed off, or have not got Netflix on the second screen. If you do, I won't know, so it won't tell me too much. But I hope you enjoyed it, and I know that you had a cracking webinar last week from Sadie and Susan to kick off this what we hope will be a pretty regular unfolding of events to keep us all going quietly mad. I've got my green screen behind me, courtesy of my lovely son who has rigged it up for me, so you don't see all the messy pottage of mishmash behind me. I understand that there is a museum of the home that is looking for photographs of just how messy our homes have become in this lockdown. You're spared a sight of mine. But what you are not spared is a couple of announcements. We're delighted to announce that pretty much as of now, we at 39 in the civil team are offering an ADR advisory service. We all know that there's a bit of a logjam on court, to put it mildly. So we have unrolled a fixed fee arbitration scheme, full details of which you will be able to find on the web as of now. And it's a mechanism of using, as you may know, we have some breadth and depth of arbitration and advisory and adjudication experience, and indeed a fair few judges who have come back to roost with us and are able to offer, along with some of us more lowly barristers, a range of skills we hope you will find of interest and assistance in helping to move claims on now the courts are not functioning quite as we may wish. And it's basically a arbitration and advisory adjudication service that we hope you will find useful. We have similarly set up a costs ADR scheme amongst our stable. We're delighted, as you I'm sure know, we have Peter Hurst, who used to be the senior cost judge of England and Wales, so he's a pretty good starter for 10 if you want a costs ADR assessment, provisional and detailed assessment, because as we all know, unless we get costs sorted out, we don't often get paid. So that's in all our interests to look at those. And we have webinars coming thick and fast. The next one we have is, no, I've got a sticky here we are, is on the 5th, is next week. It is Susan again and Nick Greeney. So Susan Rodway and Nick Greeney will be talking about the carer's liability and the cases of Morris and Barclay and X, and how that sort of elastic vicarious liability is moving forward. So the 5th of May at 3:30, put that in your loaded social diary. If you should happen to find yourself at home, we would be delighted to see you again. It simply remains for me to say thank you very much if you're still stuck with me, for staying with us and for joining me today. If you've got any queries, please email me, that's my email, or the clerks, and we would be delighted to help you if we can. Thank you very much indeed for listening, and have a lovely evening.